is nothing but piracy. The word you normally hear, there is piracy, there is piracy. So that one is infringement. So which section do infringement falls under? Section 35 provides against infringement. And when somebody infringes on a copyright work, when he has been taken to court or not taken to court, when he has been found or she has been found to be infringing on a copyright work, a civil action can be taken. We can see if that work or if that person can be taken civil-wise, can be taken on a civil suit, or a criminal prosecution, where now we can arrest and we prefer charges to that person after investigation. And that means we have to take that person to court. We have to produce evidence that he was really or she was really infringing the copyright work. And we testify also to that effect. And also there is reliefs. They can talk about that. They can arbitrate that complaint. They can talk and then they will come up with a solution. So what are the penalties of this infringement? There is a fine. If you are taken to court, you'll be fined, or you will be imprisoned. So you will be in prison, you will be fined, or you will be fined and also imprisoned. There is also injunction. There are also take-down notices, and then there are damages. You have to pay for damages. Take-down notices are these when you are found to be the service provider has enabled, there is this one, the one for DSTV. So when you are found to be infringing the content of MultiChoice, they have that ability to write to you to take that content down. So that take down notice, you will be given that notice to take that content which is infringing, which is illegal, down. So those are the penalties which you will be awarded in case of any infringement. We have exemptions and limitations. If you turn to your guides, a guide to copyright, all these things which I am presenting are found under this booklet, a guide to copyright. So if you can turn to your pages, page 6 of this guide to copyright, you can see the exemptions and limitations. Not all uses of a protected copyright work amounts to infringement. I've talked about infringement as piracy. So not all works falls under, can be classified or can be said they are being infringed. There are other circumstances where such exemptions are allowed. Like the exemptions which are allowed are for research. You can use that work, not necessarily infringing, but when you are using for research, it is allowed. Private use also allowed. For review or criticism, it's also allowed, and also for reporting current events. So when you are doing all those things which I have said, which are on the screen, it cannot be said you are infringing that copyright as long as you are doing all those things: fair dealing, research, private use, review, and criticism, and also when you are reporting current events. These are the statistics, which are not, it's an approximate. It's not by any study, but approximate that we have come up with. The civil cases or civil without consent, they are 40%. Civil breach of contract, those people who have breached the contract, 20%. The criminal copyright offenses, those which have been taken to court, 30%. And those which misunderstood rights or images, unfair trade secrets, among others, are 10%. I also, when I was introducing the mandate of copyright, I talked about the collective management organizations. So Kenya Copyright Board normally monitor the activities of the collective management organizations. Which are these organizations? They are the MCSK. So you've heard about MCSK? There's MCSK, there's CAMP, there's BRISC. All those are collective management organizations. Those are organizations that make profit. They do a work for a profit-making entities. So these collective management organizations, what do they normally do? They collect, they distribute royalties, and also they are supposed to monitor the work of the artist. So we are going to look at registration, copyright registration. Initially, copyright was physically registered. It was being done at our office physically, but we have come up with an app for registering these copyright works, and it is called NRR. If you look at your booklets, there is NRR. The one like a service charter. The one like a service charter, there is NRR, or not unless you are not given. The service charter, and then there is an NRR. I think they are still there. Yes. 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 So we came up with this ICT system hub, which is now being used to register copyrights and related rights by the copyright owners, and it is called NRR, the National Rights Registry, which you can also, if you log into this website, this nrr.copyright.go.ke, it will show you how to register your work through this system. And what is the purpose of this system? The purpose is to license, to collect. It has a licensing module. It has also collecting module, distribution module, and media monitoring module. The National Registry, it's a national central database. As I've said, that KIPI is also keeping the data bank of all authors or composers or creators of copyright. So this registry also is one way of keeping the data of all the composers, the producers, the artists, and we can also be able to monitor. But for now, it's only being used for registration. They haven't done the monitoring and the collection. It's not effective. It came up, this system came up last year. So the only thing that we do with this one is registration only. So we can see also the registration of this copyright through, if you can see the pamphlet, you can see the process on how to register this copyright works. All works can be uploaded to this NRR. All those categories of work, the sound recording, the artistic, the musical, the graphics, the films, and also architectural works can be uploaded and put it on that NRR system. So you can read for yourself the value. Why do we register? Why do we register? Why the work can be registered? And we can see several values of registrations or reasons for registering copyright. And after somebody registers the work, he or she gets a certificate. There is a certificate which can also be an evidence in a court of law that this is your work. You register your work. If there is another person coming to claim that this is his work, you can always produce. We can always refer to the database of this artist by retrieving the certificate. We remain with the copies of certificate while the original copy is given to the owner, the copyright owner. So those are the values, those are the reasons for registering. So if we can go step by step, on how to register copyright. If you can see step number 1, you will be required to fill the primary titles of the copyright owner. These are the titles that will be used to generate copyright certificate. As I have said, there is a certificate after registering. So if you log into that, you log on to nrr.copyright.go, you will find that interface to fill those titles which you are required to fill. Primary titles. We can, if there is time, we can also do a practical part of it. looking on to that one, and then we see where the primary details, and you fill those details. And then step number 2 is the stage where you will enter details regarding the copyright work you intend to register. So that one is the part of your work. The first one is the particulars of the copyright owner, your name, your ID, your phone number. And then this other one is about the copyright work now you are registering. Are you registering as one work or one or several works ambaye you have combined? And then in that step number 2, in that category, there is a copyright category, there is also subcategory. There is title of the work, the language, and the date released, among others. You can also upload at this point, at this step number 2, you can upload the work, and then you put it at this interface at step number 2. And then step number 3, at this stage, you'll be required to input the details of the people who owns the copyright. You'll be required to fill in details of others, and the person, let's say that person was assigned that through a license. So you will also use this step number 3 to fill in those requirements. And also there is a part of percentage. There is a percentage if there are several owners, you will allocate the percentage. Maybe you are the 50%, and then maybe another one, 20, and then there is 30%. So you will allocate the percentage of the work you are filling in that stage. Stage number 4, you will be required to upload any supporting document you may have that can show ownership. For instance, if there is a contract with another party on the use of work, or if there is a license certificate. So all those, and also that license or the contract can be uploaded at this stage, which is stage number 4. Step number 5. This stage gives you the opportunity to review. So at this stage, you can review what you've captured in the first, second, third, and fourth stages. And if there is any amendment you want to make, you will make it at this particular stage. And if you don't want to amend anything, it is at this stage that you will click register now, because there is no amendment you want to make. So you can register now by clicking the box where there is register. There is a button for register. And at this stage, the process is now complete. You'll be notified whether the process has been complete and to await a certificate. So that one is being done by our CEO. Now is the only person who is able to confirm the registration of these works through NRR. Madam, is there enough time we can demonstrate how to register?
Let's make a proposal.
Yes.
You wanted to demonstrate how they can register their work.
Yes.
I'm suggesting we break for tea
Okay,
for maybe 15 minutes.
okay,
15 minutes at most.
okay.
Then we come back. You can demonstrate
Briefly.
and finish your presentation so
Oh.
that you can then allow questions after.
Okay,
Yes.
thank you.
Okay. I would suggest we do that. I think it's more convenient because I think this is the point where you can now take a break
Okay. So,
without necessarily disorienting people from the flow.
we can break for a break so that when we come, we demonstrate and then we take up questions. Thank you. the last page, the second last page, you will see the procedure on how to register through NRR. And what are the requirements? So before you register, you have to have a smartphone, a laptop, and a valid ID, also a KRA PIN, and also a business registration number if you are registering for a corporate account. So I think we will take particulars of one person to volunteer, to come and volunteer the information, maybe the ID, the email address. I can't use mine because this is my organization. Okay, come. Thank you. So let's have our phones connected to internet. Just come. Oh, you can come this side, yeah. So are we all set? You have all the phones. You have the internet. You have the data bundles. Yes? There's Wi-Fi, okay. So, can we have our phones? Google, go to Google and then enter this nrr.copyright.go.ke. Are we there? nrr.copyright.go.ke. Are you able to see a screen like this? Okay. So we create an account. Click on account. So you yourselves, you'll create your own account using your own PIN number and also your own email address. So for the demonstration, we'll have the particulars of Madam so that we see what will happen next. So creating an individual account. Click on that one. And then you create individual account. You will see the name, the first name, the last name, the national ID, KRA PIN, mobile number. Verification code is the code you will receive. So that's why you are supposed to have a phone so that you will receive the code when you will register, you will have that code. Then the location, the password, then you confirm the password. Are we doing? Okay. So after filling all those requirements, you will receive a validation code. You enter that code and complete the account creation process. Are we done? Not yet? Okay. Yes. You register the one for Madam. So you are seeing the screen? Esther ID number, KRA PIN, mobile number. So we are assuming we are registering a musical work. That CD, the music, the audiovisual work. Are we almost? I've seen people don't remember their PIN numbers. And the bank. And the password for all the phones you have. Okay. So while doing that, think of a title of a music you want to register. The title of that work, like the one I gave you the example for Rose Buando, there is Kiatu Kifue. Kiatu Kifue is the title of the song. So are we almost there? Please hurry up because our next presenter is waiting.
Mail address.
Are you there? I hope. So you agree with the terms and conditions by clicking a tick on that one? If you click a tick on that one, have you agreed with the terms and conditions? Scroll. So create an account. Oh, okay. Yes. Are you able to see the OTP? Yeah, through your email. So you use your email to register, to create an account. So there is a code which will be sent to your... You've seen yours? Through email or through message?
Through message.
Or you can confirm through message. Message. Look at the message. You will see that number.
No. My phone number is 91.
Then you know you are registering, so the director, our CEO, will look at all this registration, but I believe he will understand and he will reject. Because you cannot upload the work. It's only a demo, but you cannot upload the work. We don't have the copyright works. So after doing that, are you able to see this one now? So if you follow the procedure after receiving that code, enter the code, and complete the account creation process. Are you there? Did you receive the code? So can you complete the registration process? Log in, you log in now, and proceed with the registration as indicated. Log in, proceed with the process now. And the first step of that one is you will be required to fill the primary details of the copyright owner. These are the details that will be used to generate the copyright certificate. So after completing that one, you complete a registration process. Where are you? You've logged in already. Approve application. So you make now an application. Yes. Are you able to see this one? Make a new application. You make a new application. So if you make that new application, you will see your screen portraying primary copyright owner details. Are you able to see those one? So those are the primary details you will enter, and then after which you will go to the next step. After you've entered your primary details, you will go to the second step, third, fourth, and fifth. Fifth is where you will amend if there is anything you missed or anything you wrote wrongly. At this stage 5, you have to amend those requirements or the records. And then after which, yes?
We start on the verification code. How do you do this?
The verification code. After you create an account, you will see that you create an account. Was it an individual?
Yes, individual account.
And then you will see that code through the message. It's not coming. Or maybe you entered the wrong information. Has to be genuine information, especially the KRA. The KRA normally links you with the name. So if you entered the wrong name, maybe, or the wrong PIN number, are you the only person who never received the code, the verification code? Any other person? So from there, you will follow the step 2, the step 3, and 4. And 5, you will verify you'll amend if there is need to amend the documents you've entered at the last stage of stage 4. So if you don't want to amend that one, you will go to register now. You will register. At the end of it, you will see the box with register. So if you click that one after entering all those and amending the requirements, you will click register, and registration will be captured at our office, and the CEO is the one to see your application. So up to there, we don't need to proceed, because if we proceed, it will capture and then it will be rejected, because there is somewhere you will upload. So on 2 issues I want to clarify. On the fees, registration fees for a copyright work, it's free. It's free up to 30th, up to the end of this financial year. So come July, it will depend on the copyright work you want to register. And if you see your service charter, you will see where there is a registration, our ranges of services. So there is registration of copyright works. So it depends on the type of work you want to register. Like if you want to register software as an individual, you'll use 500. You'll have to pay 500 shillings. But if you are registering for a corporate, you'll have to register, you have to pay 1,000 shillings. And duration is 48 hours. If you pay, you come and register. 48 hours utakuwa umepata nini? Certificate for software. All of it, apart from the one with assignee, the assignment, it will take 3 days. So for now, it's free. So if you have a copyright work to be registered, please register before the end of this month. If it's goes to another month or next financial year, it will capture as per the attached payments. Until the end of this year, this financial year. The financial year normally ends in June, at 30th June. So from next year, July, it will reflect as per the type of work you want to register. So I think after there, I've finished with the presentation. So not unless somebody asks a question. And yes, there is the first person. Yes. Yes, you can.
So, good morning.
Good afternoon.
Good afternoon.
It's already after, no, morning. Sorry.
So I want to appreciate you for the good presentation. My concern is I have a company and I have a logo. Now,
What?
I have a company registered and I have a logo. Now, can I...
Alone?
A logo. Logo.
Oh, a logo.
Yes.
Okay.
Can I register the logo for copyright? Logo, company logo. Just
Company
like
logo,
the
I
one...
think it's protected under industrial property. Should be protected under trademark.
It's not artworks?
It's not copyright.
Okay, thank you.
The logo itself, but the work, you can register under copyright. But the logo, you register under industrial property, which is trademark. Yes. So you want to register the logo plus the work?
The logo itself, the component that is captured in the logo.
So the logo is what you want to register.
Yes.
So you can talk to Mr. Nani, Mr. Madenge. Oh, Mr. Chege, sorry.
Okay. Yeah, thank you very much. I just wanted to make an inquiry because in the salons, when you're waiting at the doctor's clinics or some other places, you hear music playing, and once in a while they say, "Hey, the copyright people are here. Ebu simeni your music." What is the guideline of the Kekobo to people who play others' music in salons? Why do they have to run away? Because you said you only have one office and you can't be in the whole country all the time. Why can't what's required be known so that people just do it and then comply? Thank you.
So what we normally do is, there must be a complainant, and there must be a complaint. So in case you find your music being played in a shop, a movie shop, or maybe at another place, maybe a premise, and you have to launch a complaint. We can't come and just arrest somebody, yet there is no complainant. So you have to come and raise that complaint. You don't have to come to our office. You can raise that complaint through email. And our email is at the back of this pamphlet. You can raise that complaint through email. You can also go to a police station. We work with the law enforcement agencies, the police, and what is required of you, we normally train them that if somebody comes and reports a complaint of an infringement, you need to ask these questions. One, you need to have your copies of that copyright work, the original copy. What do we mean by original copy? Original copy doesn't matter. It doesn't matter about the quality of that CD. For something to be genuine, it must have a sticker. There is what we call the authentication sticker, which is a requirement to every CD. When displayed on a shop or a premise, it must have that sticker for it to be called genuine. So when you go and report to a police station, you have to have that copy. That copy of your CD must possesses the photo, your photo, not the photo of another person, your photo. So the officer will verify your photo with you yourself. And then they have to record that complaint After recording the complaint, they will accompany you to the premise, to where the infringement is taking place. From there, you are the one to identify your work. They are not the officers. We train them, but you are the person to identify your work, or if they will assist you to identify, they will go through all the music which are in the shop. So you will pick yours, which is infringing. So you will not go to a police station when yours does not meet the requirements of authenticating that music. Okay? So, and then, yes.
My name's Tim Kosuke. I'm referring now to the software.
Software.
Can you be able to upload it in the same?
The software?
Yeah.
Yes, the software you can upload, but you cannot reveal the source code of that software. There's a case I am handling about software. Somebody came and reported a case of infringement, the infringement of the source code. Someone cracked the source code and he accessed all the information of the complainant. So now that I want that person, I don't want to take that person immediately to court. So I want this person, the accused person now, to come and show us we don't want the source code because he cannot reveal the source code. So he needs to come to the office. We displayed it at our boardroom together with the complainant. And when we will display side by side, we'll be able to see which one is infringing and which one is genuine. So when we will see the one infringing, we'll tell this person, this one is infringing this one. Are you able to solve with the complainant? Are you able to see it? And then you pay the damages and what have you. And if he disagrees, we'll take that person to court. At times we have alternative dispute resolution, which is being handled by our legal team. At our office, we have departments. We have legal department, which are dealing with civil and also criminal cases. Initially, they were prosecuting copyright cases, but they were decasseted based on some other issues which arose, but they haven't been recassetted again. They are not yet. So they are dealing with civil issues and also issues of resolution, dispute resolution.
So how do I register my software? If I have a software program that does something, how do I register with it? Because I think it's a copyright, isn't it?
You have a software, then you want to register. So you will follow the procedure, which is this pamphlet. You register, you upload that software, but you cannot reveal the source code. You upload the software itself without revealing the source code.
Okay, and
is it software dealing with what?
Yeah, software. It's just a software. It's okay.
Software.
Yeah. And you just mentioned that it is free until 30th.
Yes.
If I upload now, will I be issued with a certificate?
If you upload it now, yeah, you will receive the certificate. Yeah. But I'm not very sure if you will receive it today or maybe tomorrow. But the requirement is that you will receive the certificate within 48 hours. Yes?
Thank you. I'm Job Mayaka from Olesos Technical. This is the most touching to us as trainers, and we could like to know, supposing there is a past paper from NEC and it is
There's an
copywritten.
echo with your mic, an echo.
Okay.
Maybe you can stand.
Yeah, so I was saying,
Yeah, it's okay. You are okay, yeah.
I was saying that most NEC papers are copywritten, and then I find this past paper and I want to maybe give examples in my class. Is it, am I infringing on the copyrights of NEC or am I not? Furthermore, if I write a book and then I copyright it with examples that are derived from another book, somebody else copies the same examples from me and a few others that I have added on my own, will he be infringing on my copyrights? And then, lastly, can something like a style, maybe something like a dance move, can it be copywritten, and then can somebody infringe by copying that dance move? That is what I wanted to ask. 3 questions in all. Thank you.
Yes? Okay, thank you.
Yeah, my first question is a follow-up of what Tim was asking. I've tried to go online in this application form, and the download required there is more or less a PDF document. So how do you then download, say, a mobile app in a PDF format? That's one question. Then the second one is also a percentage of ownership. There is a section of percentage of ownership there. So what do you put there in the process of application?
I think I didn't get the second question. The issue of percentage?
The second question in this application format is, I think in section 3 of the registration process, it asks about the ownership, percentage of ownership. There is something like that. And it ranges from 1, 2, 3, 4. So how do you feel in that? It is at the registration section level 3 of the registration process.
Okay, I think I will start with your questions. Yes?
Thank you for the presentation. I have a question regarding the legal part. For the legal process, how are you the people to execute or the complainant? Remember always in Kenya, for justice or any legal to be served, it's direct proportional to the depth of your pocket. That is, for any complainant nowadays, even if you want to take a police officer to premises or so, of course you need to part with some coins or so. So how do you people, are you the one to facilitate a legal action or the complainant, that is? Thank you.
Okay, let me start with you on the issue of legal. The legal, it depends. You've said somebody had to pay out the coins for your case to be handled maybe in a police station. I don't dispute that one, because I am not maybe there when you are reporting your case. But on our case at the office, we don't charge a complainant reporting a case, and we demand for a fee to be paid when we are executing a raid on infringement of your work. No. Legal, they were, initially they were prosecuting the cases. And because of some few things which arose during the process, they were decasseted. So they are no longer prosecuting our cases. They are being prosecuted by the ODPP, Office of the Director of Public Prosecution. So ours is to execute the arrest and prepare the file. We take this person to court, and we take the file to ODPP's office. So it's up to the ODPP to confirm that this person stands to be tried in a court of law. Or if there is something, there are evidences still missing, they will send you back, collect these evidences so that the case will be strong. For maybe under the alternative dispute resolution, they don't charge. You come, they will talk to you together with the accused person, and they will not judge. It's free. So to your question at the back, the issue of percentage, you are the one to allocate the percentage when you are registering through NRR. Are we together? So you are the person to allocate the percentage. If you are the owners, you want to register 4 owners at that box, you will write the first owner with percentage. Ni kama ile shares ya register company. So you have to write the directors and also the percentage, the shares, and by everyone ana hold. What was your next question? You want to register software? A movie? You download the software? Or you upload the software? Or you are in uploading a software in PDF? Should be in a PDF. So you know about PDF? Yes. If you download it, you upload it in a Word, it can be interfered with. But the PDF you cannot change. See
what I'm asking is?
Yeah.
If you are doing this thing in a computer, if you are, if it's a mobile app, you have to go to Play Store or maybe Play Store, for example, you download. Whatever you download is more or less installed. So, or you can transform whatever you download into PDF.
So if it's your software, see, you have to be giving that in PDF format. So even if it's in Word, you have to convert that one to PDF so that you upload when it's in PDF format.
Well, the thing is, a software can never be removed, but anyway, it's okay, I get it.
Yes?
I think you can do the documentation part of the tool or the system itself, because you cannot upload the system. It's just maybe the explanation of the documentation that explains explains how the system runs, what it is, specifications, what it does. Then the system has a documentation part of it. So I think it's the documentation that we are approving. Right.
Yes,
For
the
example,
document,
I
yeah.
mobile app. But you can upload the documentation explaining that mobile app.
Yes,
Is that correct?
yes,
That's correct.
yes,
You upload the description of the innovation.
yes.
But not the application, not the application of what you want to protect.
You are saying?
You upload the description of what you want to protect, isn't it?
Yes.
But not the application itself. Because I'm trying to imagine how can you change it to PDF.
So there is application and then there is the description. So I think I haven't dealt with the software, the uploading. See, I've told you that the person who is confirming the registration is our director. So I haven't seen the uploading of that, that software registration. So I believe the application, the description itself is the one to be uploaded.
Then it's going to be interesting because you might have different applications but doing the same job. The description is going to be the same, isn't it?
But there is an office who is supposed to verify that one, the ICT office. The director cannot deal with issues of software. There must be an expert on that one to verify. Even if it's a description, he has to compare this description and this other one. And you cannot be issued with the certificate if the description you are giving out is the same as the one already registered.
Yeah, because I was trying to imagine, for example,
Yes.
I've developed something for voting, a system for voting electronically.
Yes.
Right?
Yes.
Somebody else develops the same thing. But you know the application might be different, it may not be the same. So how do you differentiate the two now?
They are experts. They are experts who can differentiate. So if you want now to register, if you register, there is always that expert in our office who will differentiate between the softwares. Okay. So your question is about newspapers, journals? Past paper of NEC. I talked about limitation and exceptions. When you are doing it for research, for fair dealing, we see copy the whole book, wanna copy part of it, and the law is allows. Is it private use or domestic? But is he using for private use or domestic? So if he's using it as a private use, you are in a shida, but if he's using it to make other copies for other people, you launch a complaint, we come, we see. But Sharia, the law allows a certain percentage, and also it depends, how is that person? Is it being used to translate it into Braille? Because they are allowed even to copy the whole book. to copy the whole book, but it's being translated into Braille. A dance move of yourself, or you are the one dancing? Can you? I don't see it as an infringement. But are you getting, is that person getting anything about after dancing? Is he getting? So that one can be an infringement. If you dance and then another person dance the same and is getting money out of your dance, it's infringement. And maybe the last one at the back.
Mine is not a question, it's just a the discussion is going on. I'm just reflecting from what we have those things that are non-pertaining. And maybe probably the presenter yesterday saying that even a sporting activity like double football or playing in a field where we have a double field is not pertaining. So I think that's just my thinking that we still have gray areas which probably your team need to look into. Software, probably if there is no similar way of taking software, I think we can borrow from people who have more diversity way of looking at it. Then the other gray area is about now what my colleague has just said about like there was a time we were so much into during the corona pandemic into the Jerusalem dance. And almost every institution was involved in dancing. And somebody somewhere from South Africa said that there will be a legal action towards those people making use of our dance. This is as a country, we really need to be more strategic and see how best can we make use of the institutions to either protect or to safeguard an institution probably who might have either imports infringe into somebody's dancing rights or dancing style. So I think the discussion is really getting us very nice.
Thank you very much, ladies and gentlemen. Thank you so much. Can we please appreciate this? And I think this discussion is going to go on even in the afternoon after Violet gives her talk, and I think also the KIPI people. I just want to recognize the presence of our director who was not here yesterday, Professor Balozi, kindly.
Good afternoon. Welcome all of you. I'm sorry yesterday I couldn't be with you, but I'm sure you're in good hands and we appreciate your presence here. My name is Professor Balozi Bekuta. I'm the Director of Income Generation Activities for the university, but I'm also Acting Director Research and Innovation. And I'm happy that I've picked already a few areas where I can use to make money for the institution. Please allow me also to introduce a few of my colleagues. We've got deans here and directors. So I'm just requesting that they introduce themselves very quickly, and then I also have heads of sections who are here from the university. So please, if we can do that, that will be really nice. Asanteni.
I thought I had introduced myself. In what capacity? Okay. Yeah, because I have to ask in what capacity, because yesterday I think I had introduced myself. Nevertheless, my name is Professor Robert Otuya, Dean, School of Business and Management Sciences, and also Chair of Income Generating activities. So I work closely with him. Thank you. Who else is that? Huh?
Good afternoon, everyone. My name is Dr. Zachary Shitote. I'm a member of the Board of Income Generation and also on the school research team.
I'm Dr. Curious Shichika, a member of the research team.
Dr. Celine Harono from Department of Biological, a member of the research team. Thank you. Okay, she's reminding me something. I also am chair HIV/AIDS committee, AIDS Control Unit, University of Eldoret. Thank you.
I think it's not working. Hello. Yeah, my name is Daniel Murgor. I am representing the library. Yeah.
I'm George Aria, HOD, Tourism Management, member, IGU board, and also a member of research team. Yes.
Hello, my name is Shem Mwasi. I'm the chair, Research and Extension Committee, School of Environmental Studies.
Hello everyone, I'm Jennifer Rono. I'm a member of the research team. I'm also the assistant registrar in charge of content creation in online learning.
Good afternoon, everybody. My name is Victoria Njichi from School of Agriculture and Biotechnology. I'm also the head of department of the horticulture section. Thank you.
Good afternoon, everybody. I'm Samuel Luther, Dean School of Science. Thank you.
Yeah, good afternoon, everybody. Yeah, my name is Alkamai Boniface from the School of Agriculture and Biotechnology. I'm a committee member of the IP. Thank you very much.
Good afternoon. My name is Dr. Johnston Kimansi. I'm HOD, Wildlife Management, and also a member of the Research Committee.
Okay, good afternoon, everyone. I'm Joan Koech from Biological Science, Lab Technologist.
Okay, we had several members from UOE. I can see some of them have just stepped out briefly. So those are some of our people here. And I'm now going to introduce some of our guests. I'm going to start with KIPI. And I'm going to start with David Njuguna. Is he here? Okay, he's not, he's stepped out. Mr. Paul Chege. And Paul is also an alumni of this university. This is the original alumni. I'm also going to introduce Mr. Ruben Langat from KIPI. Then I'm going to introduce the Eldoret National Polytechnic Group. You're here, kindly just stand so that we can see you clearly. That is Emmanuel Sawe and Daniel Rotich. The RVTTI group, are they here? So that is Gertrude Chepkirui and Robert Rob. The Moiben Technical and Vocational. So there are two. So we have Geoffrey Biwot and Nora Tisi. Then we have the Turkana University. So there we have Dr. Kenneth Sirma and Mr. Muyesu Shadrach. Then we have Tinderet Technical. So that is Fred Rotich. Then we have Emining Technical and Training. Meaning, looks like they are not here just now. Then we have Olesos TTI. So that is Paul Tabut and Job Mayaka. And then we have Endebes TTI. I think they came late. Thank you so much. Then we have Baringo. Yes, so that is, those are our guests. And of course, we have our guest from Kekobo, Kenya Corporate. She has just done her presentation. That is Emily Cheruiyot. And our next speaker, who is Violet Ibamba from KEFIS. So that, yes, Ibambe from KEFIS. So she's our next speaker. So that is everyone in the group. And of course, we have our technical team there that is making everything work. We have our secretariat. So most of them are actually our interns from ICT. And of course, the team that you can see here ahead of you that has enabled this everything. So I think that is everyone in this room. And of course, there are some who have just stepped out. And of course, we have our person here, you always get forgotten. Okay, team, just introduce yourself. I don't want to introduce you.
My name is Tim Koskei, Department of Physics, but I'm attached to Intellectual Property Management Office. More or less on IP.
Okay, and myself, my name is Professor Lizzie Mwamburi. I'm the IPMO, and I'm also in the Department of Biological Sciences, School of Science. So welcome, everyone, once again. Thank you very much. So I think, Violet, if you're ready. And of course, we also have our virtual participants. They are virtual, you're also welcome. Out on the topics that I'm supposed to cover. I'm supposed to dwell on plant breeders' rights. Under that, I'm supposed to give an introduction, and then the subject matter protected by plant breeders' rights, procedure for registration of new plant varieties and plant breeders' rights, rights and obligations of the rights holder, limitations and exceptions, term of protections, and the fees. But you
You can see our head office. There's a building there. Those are our Nairobi head office. And we also have regional offices that cut across the country. We have an office at Jomo Kenyatta International Airport, in Mombasa, in Kisumu, Nakuru, Taveta, Loitoktok, Namanga, Isebania, Mbita, Lungalunga, Bura, Naivasha, Embu, Eldoret. We have an office at the airport, Eldoret Airport, and we also have a desk at the Huduma Center. We have an office in Kitale, Malaba, Moyale, Moguga, and Lamu. In total, countrywide, we have 20 offices. And we carry out various services. We carry out phytosanitary services. Phytosanitary being a terminology simply referring to the cleanliness of plant materials. We also carry out seed certification and plant variety protection services. We also do advisory services to farmers and the general public. We also normally participate in shows, field days, and stakeholder forums. Like what I'm doing right now, I'm participating in a stakeholder forum. This gives us an opportunity to continue spreading the gospel about what KIPI does. Just to tell you something small about phytosanitary services. Under phytosanitary services, we normally carry out inspection and certification of imports and exports of plant materials. This includes fruits, vegetables, flowers, propagating materials, etc. We also normally do plant clinics where we do diagnostics if we have farmer groups or any institution, if they have any issues with their plant materials related to issues of pests and diseases. KIPI comes in handy. We carry diagnostics and then we can advise the farmer on the way forward. We also carry out farm audits. We also carry out fruit tree nursery inspections and certification. So the fruit tree nurseries that you see in the country, it is a requirement that they approach KIPI. They do an application process so that KIPI can carry out inspection of that fruit tree nursery and then issue a certificate so that you can market your fruit tree seedlings freely without any fear or favor. Under seed certification and plant variety services, we normally carry out inspection of crop seed fields. You know, we have the seed merchants, the companies that sell seed. I know many people only know of Kenya Seed, but we have so many seed companies in the country. So all these seed companies, before their seed goes out to the market, it is supposed to have passed a rigorous check and inspection services by KIPI. And it starts right from the breeder. The breeders normally carry out breeding work to develop the new plant varieties. KIPI is in there checking these varieties. The varieties are released, and therefore the breeder is supposed to do multiplication of those varieties so that they come in bulk enough for the farmers. KIPI is also there supervising that exercise. They will carry out processing of that seed. KIPI inspectors are always in all the seed processing plants and factories, ensuring that the process of processing the seed meets the minimum requirements. The seed now goes out to the seed sellers, the seed outlet shops, the agrovets that you see in town. KIPI normally goes out to follow up on those distribution outlets to make sure that the seed being provided or being sold to the farmers is actually meeting the minimum requirements. The storage conditions are as per the requirements, and the person selling that seed is also meeting the requirements as per the regulations and the laws that are in place. I've been told that I have a right to go outside what was sent to us on this document. So as I will be going through the presentation, I will be explaining further, because when I was preparing my presentation, I narrowed down to what we were sent. But then I have the blessings of one of the organizers. I can explain further to you in details so that you can really get to know what KIPI does. Just as part of an introduction, plant variety protection, which you guys will call plant breeders' rights, which is the main theme for today, is administered by Kenya Plant Health Inspectorate. And KIPI is a state corporation under the Ministry of Agriculture, Livestock, Fisheries, and Cooperatives, whose mandate is basically to regulate the agricultural sector. It was established through a legal notice under the State Corporations Act in October 1996 and commenced operations in 1997. Currently, KIPI operates under the Kenya Plant Health Inspectorate Act of the year 2012. Just like any other organization, we also have a mission and a vision. As you can see on the screen, that's our mission and our vision as an institution. And it narrows down to the issues of the plants, where our mandate lies. Now we are home. What is plant variety protection? Or you could as well ask, what is plant breeders' rights? So when I talk of plant variety protection, still remember I'm still talking about plant breeders' rights. These are basically rights that are granted by a state to protect the breeders against infringement. I'm glad the presenter and my co-presenter, Emily, who presented, whatever language she was talking, I could associate, I could relate. Because I was like, we are doing basically the same thing, only that them they are regulating something else, and as we are regulating something else. But the language she was talking is the same language I'm gonna talk to you today. So here, the plant breeders' rights are basically those rights that are granted to a breeder who has developed a new plant variety so that no any other person can use this new variety without the permission of the breeder. We are home with that, eh? And the plant breeders' rights can be transferred from one owner to another owner. They give the breeder that exclusive right to produce for sale and to sell any propagating materials of that particular variety. We grant plant breeders' rights for all plant genera and species apart from algae. We continue with what is plant breeders' rights. Why? Now I want to tell you why should we protect the breeder and the new varieties. There's a reason for this. During development of the new varieties, if you've interacted with the plants and breeding systems and works, you will get to understand that breeding is not an overnight game. It takes several years. And during the breeding process, a lot of money is used. Therefore, if this breeder is not protected so that he or she is able to recoup the investment that they put into the breeding work, then aren't we killing the breeding work? And as we are killing the breeding work, then it means that Kenya, especially the Kenyan farmer, will not have an opportunity to access superior varieties. Because we expect that during breeding work, this breeder is supposed to come up with varieties that are more superior than the indigenous varieties that we were used to. So if the breeder is not protected, so that they can recoup the investment that they put into any breeding activity they do, then it means that they will be discouraged to continue with the breeding work. And this means we will not have access to new, superior plant varieties. Therefore, to encourage these breeders to carry out the breeding work and give us an opportunity to access new plant varieties which are more superior than what we have been using in the previous years, they must be protected. And they are protected through granting them the plant breeders' rights. As we do our work, we are working within a legal framework. It's not just from nowhere. So anything we do under the CAP 326, which is the Seeds and Plant Varieties Act, which came into effect in 1972, and it has been undergoing several reviews, the latest being in the year 2012. We also have an official regulations which guides the implementation of the Plant Variety Protection Service System, which was put in place in the year 1994. The Office to administer the plant variety protection systems was established in the year 1997, but became functional under KIPI in the year 1998. Now, who is eligible to apply for the plant breeders' rights? Who is allowed to apply for protection under the PBR rights? It is only the owner of a new variety who is entitled to apply for a grant of the plant breeders' rights. And the owner of the plant breeders' rights may be the breeder of that particular variety, or the person who discovered that variety, or the employer of this breeder, or the person who discovered the variety, or the successor. Remember when I was starting, I said the rights can be transferred, right? So if they are transferred, then that successor is the one who will now be able to apply for the plant breeders' rights. Here, if I talk of the employer, we have breeders in the University of Eldoret, and we work closely with them. So these breeders from the University of Eldoret, since they are working for this institution, then the University of Eldoret is the one that now qualifies to be the owner of the variety. And therefore, the institution is the one that will apply for the plant breeders' rights. An application may, however, be made by an agent on behalf of the owner. The institution can take a lawyer or any other agent so that they apply for grant of the plant breeders' rights on the behalf of the owner. What are the requirements? For you to qualify for the grants of the plant breeders' rights, what are you required to do? What should you put in place so as to qualify? Or what should be done? Or what is the procedure? After you make an application to KIPI, KIPI will carry out a test to confirm if your variety is new, if your variety is distinct, if your variety is uniform, if your variety is stable, and also if your variety has got a denomination. Once you meet that criteria, then you are on the right track. Therefore, KIPI will carry out a distinctness, uniformity, and stability test on that new variety. These trials are normally carried out for a period of 2 growing seasons. If your growing season is per year, like let's say you, in your area, you plant the varieties once in a year during the long rains, then that one will be considered a growing season. Then your second growing season will be the next year during the long rains. But if you're using irrigation, then you can have in 1 year, you're already through and done with your 2 growing seasons. Therefore, it is the data that is collected for those 2 growing seasons that will be compiled and analyzed, verified, and then that is what will be used to ascertain whether your variety meets the distinctness, uniformity, stability, novelty criteria. Upon completion of this DUS trial, the breeder can now apply for the plant breeder's rights, which will be granted or refused based on the DUS results. There's something that we call a protective directive. Here, the protective directive, this is an application by the breeder while they are still waiting for the DUS results. So the breeder can make a can apply for a protective directive so that the variety is protected pending the DUS results. Remember, if the DUS results take 2 years and you're still sitting down waiting to apply for the plant breeder's rights, somebody may also be working on the same variety, and therefore they'll do an application before you, and therefore the right of priority precedes. The application that comes in first is the one that will be considered. Therefore, a breeder may decide, while I'm still carrying out while the DUS trial is still undergoing, let me apply for a protective directive as I wait for the results. Immediately the results come out, a committee is convened, which is called the National Varieties Release Committee, discuss the results, and pending, based on their decision, the variety will be recommended for release. And now after that, that's when now you'll apply for the plant breeder's rights, which will be processed, and you will be given a certificate. I have the fees for whatever I'm saying at the end, so I'll not mention the fee or the charges for the various activities that I've mentioned. I talked of, for a variety to be granted plant breeder's rights, it has to be new, distinct, uniform, stable, and of an acceptable denomination. Denomination is basically a variety name that is unique. It doesn't resemble any other name that is already in the system. So I just want to take you through, when we say new, distinct, uniform, stability, and denomination, what do we mean? For a variety to be considered new, as in it has not been known at all, that variety must, the variety and its propagating materials must not have been sold or offered for sale with the agreement of the owner in the country for more than 1 year before the date of application. So if it has been in production and commercialization and multiplication for more than 1 year, that is not a new variety. That is a variety that is already known. That is a variety that is already of common knowledge. So you cannot qualify to call it a new variety. If it is outside the country, then the variety should not have been in production for more than 6 years. That is for the woody plants, that's trees and vines, and more than 4 years for the non-woody plants. It is the responsibility of the owner or this breeder or the company that wants to apply for the plant breeder's rights to ensure that before they apply for this variety, it has not been in production or under commercialization for the time period that I have mentioned. But there are exceptions to this. This rule does not apply where the sale is part of a contractual arrangement for increasing the applicant's stock. This applicant may just have been producing it to increase his own stock, but not for commercialization. Or for evaluation trials. This breeder wants to carry out evaluation trials on his own variety, just to ascertain that it will actually pass maybe the national performance trial or the DUS trial. The rule does not apply to that. So long as this material is only consumed by the breeder and it does not use it for commercialization or with other people. The plant material produced during the breeding or increasing of stock and trials or tests of the variety and not required for these purposes is disposed of for non-propagating purposes. So remember that it's also the responsibility of the breeder. You have not yet been granted plant breeders' rights. So it is your responsibility to make sure that this material has not been disposed of for any propagating purposes, because it will definitely have been in commercialization. It will have been under production. Therefore, as you are applying, the material is already a variety of common knowledge. Distinctness. For a variety to be considered to be distinct, it must be unique from the commonly known existing varieties at the date of application, even if it's only in one of its morphological characteristics or the physiological characteristics, then that variety will be considered distinct. As in, if I plant it alongside any other varieties, I will be able to point out that this variety is different from all these other varieties based on this particular characteristic. I hope I'm not too fast, because I know I talk too fast. Tuko pamoja? Sawa sawa. If I'm too fast, please slow me down. So that is distinctness. Your variety must at least show one morphological characteristic or any other characteristic that will be able to differentiate it from all the other existing varieties. A good example is the maize varieties. I know everybody is at home when we talk of maize. How many varieties of maize do you know? Give me the names.
613, 614, 628,
628,
629, 6230.
Yes.
511.
Katumani. We have so many of them. I don't know if I came with small trials and planted them together. If you'd go there, you'd pick out 614 and tell me this is 614. This is 6213. This is 6218. This is 101. If you work for KIPI, you'll be able to do that, even if they plant so many of them, because there's one particular characteristic that will make you know this is 614 and not 6213. So that is what I'm talking about when I say distinctness. Uniformity. Uniformity basically means uniform. All the plants of the variety should have no variation in features of propagation. As in, if I have 614 and I plant it in an area, I do not expect to find any plants, if they're given the same treatment, any plants that are excessively taller than the others. I do not expect to find others that are too robust. The thickness of the stem is too off the mark. I expect that when I look at them, even the green, the color, the green color, you know we have light green, medium green, and dark green, right? So if you look at them, that intensity of the green color should be basically the same. That's when now I'll say this variety is uniform. I'll bring you home with maize, the tassels, ile vichwa ya mahindi, si mnazijua? Siwa mnaona huwa ziko na kala tofauti tofauti. Now I want to help you when you go out there and you see a maize plantation, angalieni tu vichwa. Ukiona kuna vichwa nyeupe, vichwa za cream, vichwa zingine ni pinkish, mahali pamoja na huyo mkulima anakuambia alipanda one variety like let's say 6213, then your variety is your uniform based on the color of the tassel. That variety is not uniform. If it's uniform, kama vichwa ni cream, zote zinafaa zikuwe cream. Kuna hii vitu zinaitwa silks, ikitoa cobs, siwa inakuwa na nywele. Ukipita kwa mahindi ukiangalia uone nywele zenye ziko cream, zingine ziko ile kala ya ile koti pale, purplish, pinkish, ingine ni light pinkish, ingine dark pinkish in the same population, and the farmer tells you hakuchanganya mbegu aina mbalimbali kama 6213, 614 akapanda, alinunua ikiwa 6213 akapanda, that variety is not meeting the criteria of uniformity based on the silk. Sawa sawa. Stability. During the time of application, the breeder should have done his homework very well to stabilize that variety, so that by the time it is being released and gazetted as a new variety, never at one time during its propagation cycles, ikipandwa hii mwaka ujao, ule mwingine nini, haifai kuchange. It should not change in its characteristics. It should remain like that. In season 1, season 2, season 3, it should remain with the same characteristics that it had during application and release. If it starts disintegrating and turning into something else, then that variety is no longer stable. So it fails under the criteria of stability. So as KIPIs, we normally plant a variety over several cycles. And if it comes one cycle that we realize this variety is no longer conforming to the characteristics under which it was released, then that variety definitely fails under the criteria of stability. The denomination, which is basically the name. Every applicant for plant breeders' rights must propose a name for the variety. And this name should conform to the internationally acceptable Union of Protection of New Plant Varieties guidelines on recommendation for naming of varieties. We have guidelines that we work within. So we have the international guidelines. The way we name varieties here in Kenya is exactly the same way any member states of the Union for Protection of New Plant Varieties names their varieties. So your variety name must conform to that. We go down to the rights and obligations of the breeder or the rights holder. Remember, as KIPIs are doing their work, the breeder also has got some work to do. So it is the responsibility of the breeder to carry out variety maintenance. And under variety maintenance, remember I talked of stability. So if the variety starts disintegrating in characteristics, then it means that the breeder is not maintaining his or her variety so that it conforms to the characteristics that this variety had at the time of application and release. So it is the responsibility of you as the breeder or the rights owner to ensure that your variety remains stable. It is also the responsibility of the breeder or the rights holder to ensure that they enforce their plant breeders' rights. By this I mean it is the responsibility of the rights owner to find out if their rights are being infringed. And if their rights are being infringed, then it is their responsibility to seek redress in court. They can approach KIPIs for assistance, but it is solely the responsibility of the breeder to follow up, to find out, is my variety being misused outside here. If it is being misused, then I need to follow these steps to ensure that my variety is not misused. Because the moment you sit back and fold your arms, then your variety is being misused, then you as the breeder is the one who will fail to recoup your investment. We know Kenyans, we love cheap things. You can imagine a breeder selling me the 2 kg pack at the prices that we know they are being sold in the agrovets, sindio? And then I come up, the same variety. And you know, it is very easy. With the improved technologies, it is very easy to multiply varieties. So somebody with ill motives can easily multiply your variety and sell it out there. So if you sit back and I multiply your variety and sell it at a very cheap price, half or even a quarter what you're selling, do you think somebody will come to you for that variety? See, I'll get the loot while you sit in your comfort zone, losing. So it is your responsibility to follow up, to make sure that you recoup your investment from this breeding work, this new variety. There's a fee that you're supposed to pay, a maintenance fee, annual fee. So as the breeder or the rights owner, you must make sure that you are paying that required maintenance fee as per the requirements. The rights, the breeders have got rights. They can decide how much to charge for their varieties. If somebody wants to use your variety for whatever use, you sit down with that person and negotiate how much should you be paid for the person to use your variety. So you have that right to decide the fee that you'll charge for exploitation of your variety. The breeder also must be informed in case his or her variety wants to be used to develop the essentially derived varieties. Essentially derived varieties are basically, if you can take like 614, and then somebody wants to use that variety to inject in a gene for maybe resistance to a certain disease or a certain pest, or to improve it on something, but morphologically it will remain 614. So before a person uses your variety to inject in a gene for improvement or anything, you must be consulted, and you also have a right to decide how much you want to be paid for that discussion. Term of protections. I mentioned protective direction, whereby you can apply for this as you wait for the DUS results to be completed. So this one gives the applicant an interim protection of the candidate variety while the application is under consideration. This protective directive automatically applies once an application has been made, and it will cease to have effect when the registrar issues or refuses a grant. That is for the protective directive. So once your grant has been refused, that protective directive stops to operate. And if the grant is also issued, this protective directive also stops to operate. So it can run for the entire period. If you go with your DS for 2 years, the protective directive will cover you for 2 years. If you go for 1 year, it will cover you for 1 year until such a time when it's either rejected or accepted. And then we have another protection, which is now the plant breeder's rights. Here, the plant breeder's rights are granted for a term of up to 25 years, beginning from the date on which the grant of the plant breeder's rights takes effect. That is for fruit trees and rootstocks, forest, ornamental trees, grapevines. But for all other plant materials, the plant breeder's rights remains in operation for up to 20 years. Beyond 20 years for these other plant materials and beyond 25 years for the woody plants, it is assumed that that variety is now a variety of common knowledge. It is under multiplication. Number two, it is also assumed that 25 years and 20 years of you being protected as the rights owner, you must have recouped your investment that you put into this new variety. So go out, carry out breeding work, come up with another new variety so that the farmers can continue having access to new superior varieties. I think these one have said it. As a rights owner, there are also limits and exceptions to your rights. I heard her say that and I felt very good because I realized these exceptions, they don't only apply to plant breeders' rights, they cut across. Because she also said exceptions and she mentioned what are exempted. Under the plant breeders' rights, there are also exceptions whereby other persons are free to grow or use a protected variety, but only for non-commercial purposes. If you are caught doing it for commercial purposes, be ready to face the law and to compensate the breeder in court. To use the plants or parts of the protected variety for human consumption or other non-propagating purposes. To use a protected variety for breeding work. She said for research, I'm saying for breeding work. If there's any repeated use of a protected variety for commercial production of the first generation hybrid seed without the authority of the holder of the rights, that one, you'll be infringing on the rights of the rights owner. We have the statutory fees. Remember I talked of protective directive, protection that you are given, which is temporary, only lasts for the period that you are still waiting for the DUS trials to be conducted, completed, and the results obtained. For this one, you pay $150 US. For the DUS test, which is normally carried out in 2 growing seasons, you pay $600 US. And for the plant breeders' rights certificate, you pay $200 US, which is renewable annually. This fee, it is not KIPI that came up with it. It is in the law, Cap 326. We have a chapter on fees and charges, and therefore that is where it is stipulated. We lift it from there. If they review and raise it, we'll be very happy because we'll collect more revenue. How to apply for plant breeders' rights? Initially, we used to do it manually, whereby forms, you'd collect forms from our offices, and you do the manual application, attaching the various documents that are required, and then you present them to our KIPI offices, and then they do document verification, and if you qualify, then they would process your application, and they would give you an invoice whereby you'd pay the application fees, and your DUS test would commence. But nowadays, we've gone digital, and we are doing online applications. So if you are a breeder, you have to liaise with KIPI's ICT team so that they create for you an account as a breeder. Remember, we have various applications. We have the seed sellers. So you have to be created for an account specifically for a seed seller. But if you are a seed seller and at the same time a breeder, then you'll be created for 2 separate accounts. One for a breeder, so that if you want to apply for a DUS or NPT, you go to the portal or to your account under the breeder and you make your application. If you're a seed seller, you're selling seeds, then you go to your portal, you apply under the your account for the seed sellers, and then your seed seller license will be issued. The seed seller licenses are renewable annually. Any other services, you also have an account created for you, so that whichever service you want from KIPI, you make an online application. Enforcement of PVP in Kenya. The enforcement of rights is by the owner of the rights, as I already said. This is just to emphasize. And you are the one who will seek redress in the courts. The Act also provides for a seeds and plant tribunal to determine any disputes arising from the plant variety protection issues. KIPI, being the designate authority for phytosanitary and seed certification matters, has the added advantage of detecting cases of infringement, and it has helped in arbitrating some of the cases. So if you as the breeder or the rights owner have issues and you approach KIPI, KIPI has assisted in arbitrating in some of the issues. So KIPI will also come in handy in advice and also helping to resolve the issues. Before we had plant variety protection in the country, and now we have the system working. What pluses has it added to us? As a country, since inception of the plant variety protection system, at least our farmers can have access to superior varieties. Our breeders are doing breeding work. We are exposed to so many different varieties that are coming up. Therefore, since the inception of the plant variety protection system, it has facilitated access to superior varieties, especially for the ornamentals. This leads to increased productivity, job creation, and wealth creation. Remember, if you have a superior variety, you are guaranteed of increased production per unit area, as opposed to if you use the indigenous varieties, the varieties that are not improved, the varieties that are not superior, your yield per unit area will not match up or measure up to if you used the certified seed. So we encourage anybody who hears the gospel to go out there and educate our parents, our grandparents, our neighbors back at home, the importance of using certified seed as opposed to using the farm-saved seed. It has got a lot of advantages if you use the improved or the certified seeds. In case you have any queries, you need more information about KIPI services, activities, where our offices are, job applications, etc., you can always visit our website. It's full of information about KIPI. In fact, I normally tell people the moment you go to the KIPI website, you won't even follow somebody asking questions about KIPI. In a nutshell, while you're seated on your desk, you can get all the information you want. If there are any tenders being advertised, you can access them on our website. If you have people who are looking for jobs, you can easily know when there are no new job adverts, with which kind of jobs and the qualifications, and you make the applications. So I would urge all of you to note down our website so that you will keep on visiting it whenever you're free, so that you get more information about our services. Thank you for taking your time. So I don't know if the moderators would allow me to take any questions, or what is the...
Yes, we are allowed to have a question session, so we'll allow a few. So kindly take at least 3 at a time, so that we can move quickly.
Okay.
Thank you. So whoever is ready? Yeah, next, another hand.
Thank you for the presentation. I have two questions. One, to what extent do you protect for a breed?
For?
A given breed, to what extent? Given that, take example of maize. For the second phase, somebody can pick just the outcome of from and then reuse it instead of going back and buy the other breed, of course, for the next season. Another case is like for the case of ornamental cypress or ornamental trees. For that case, remember it's one of the expensive breeds of trees that for beautification. And you find it, a breed comes today, 2 years down the line, it's all over. Everyone is like breeding everywhere. How do you people protect them? Of course, everyone is up to commercial or earning something from that. Finally, there is some breeds in the market that if you check even in the website or where I mean, you cannot find it anywhere. Are in planting season, you will get some maize, maybe seeds that's not even, I don't know, it's authorized or so, because it's everywhere. So to what extent do you people as well go into that? Thank you.
Any other question?
Yeah, in fact, he has asked 3 questions, and you told me to take 3 questions at a time. So he already asked 3 questions, but I didn't get your name, please. Rotich Fred. So Fred, if you followed my presentation keenly, I already answered your questions. I will repeat. It is that you've said there are ornamental varieties that come in, and then within a period of time, you will find them all over. Question number 1, is that variety that comes in protected? If it is protected, then it has a rights owner. And I said clearly, it is the responsibility of the rights owner to find out whether their varieties are being misused or their rights are being infringed. Once they do that, then now they are the ones to seek redress in courts and not KIPIs. But they can approach KIPIs for assistance, advice, and guidance while they're seeking redress. Number 2, you've asked to what extent is the protection? I said in my presentation, for woody plants, that's trees and vines, the protection lasts up to 25 years. And then for these other crop species, it lasts for up to 20 years. 20 years is long enough for the breeder to have recouped their investment. 25 years for the trees and vines is also a period long enough for the breeder to have recouped their investment. And beyond that, that variety, definitely 25 years is too much. That variety, you'll find it growing everywhere. And therefore, it's now considered a variety of common knowledge. A variety of common knowledge ni ile kila mtu tu anaijua. Iko tu kila mahali. Kama 614, si kila mtu anajua tu 614. So, kama imefika 20 years, protection yake itaishia hapo, iendelee kuwa variety of common knowledge. Kama ijafika 20 years under production, and the rights, the time when the application was made, up to date is 20 years, then it's now a variety of common knowledge. You asked another question about maize being grown now all over. Oh no, this was your question if I got you right. You find somebody buying certified seed, anapanda, and then the harvest, the first generation from that harvest, anaitumia panda tena. In my presentation, I said there are exceptions, right? If the farmer is using it for own use. Kama umevuna, unajua ni hasara kwako wewe mwenyewe kama mkulima. Umevuna hii, umekataa kutumia certified seed, umerudi, unajua hiyo sasa si mbegu, hiyo ni chakula. Umetumia chakula kupanda, so your yield per unit area will definitely go down. And if you continue harvesting that, replant. Harvesting, that is what we call farm saved seed. Unavuna, unachukua a few cobs yenye unapenda, unaona inakaa mzuri, unaeka kwa tabot pale juu, inakula moshi for that year, unagongoa. During planting season, you use that to plant. It is you, the farmer, who's losing, because definitely, automatically, hata mambo na inbreeding, si mnajua? Mambo na selfing, kwa plants tunasema selfing, but kwa wanyama tunasema inbreeding. Definitely the quality itaanza kwenda chini. Kama ni wanadamu, uendazimu utaanza kuingia ndani. Zile genes zenye zilikuwa za mababu zetu, sasa zitakuja kutokelezea. So you are not encouraged to use farm saved seed unless you are not interested in making profit on that small area. Nowadays, the way tulikuwa na mashamba kubwa kubwa kitambo, nowadays shamba ni kidogo. We want to maximize per unit area. So you go out there and spread the gospel. Waambie wawache kutumia farm saved seed. Wakipanda hiyo, once they're done with it, let them go back to the agrovet and buy certified seed. And something else before you ask a question I forgot to say, but I would wish to create awareness on it. We've had issues of complaints of fake seed being in circulation. But now when we follow up, because that one, its KIPI now will come in, just like my colleague here from Kekobo, Emily, we'll follow up that one and we'll make arrests and we'll go ahead and prosecute. And it is I, if I'm the one who was following up on the case, I'm the one who will stand in the court of law to argue that case out, that I was out on surveillance and I came across someone selling fake seed, and then I give evidence. But now you find that there are farmers who will buy seed, certified seed, they go, they plant, and they get rid of the packages, and they don't have any document, any purchase evidence that I actually bought this seed from this place. And then when such a farmer comes to KIPI, it becomes difficult to step in, because you know when you're going to prosecute somebody, you must produce evidence. When you're following up any complaints, you must have evidence. So we encourage anybody who buys seed, insist that that agrovet writes you a receipt that will show you bought this seed from this agrovet on this particular date, this quantity. And the packages, you keep them. For the receipt, it will help us to follow up on the dealer whom you bought from. For the packages, it has got very crucial information on it. We have something we call a lot number. Every production during processing, huwa inapewa lot number. And as KIPI, we pick a sample from every lot number, we carry out tests, germination and purity tests. So we will follow up and see, lot number, was it really processed? Ama somebody has just faked a lot number. And if it was processed, did it undergo tests, purity and germination tests in KIPI? If it did, what were the results like? If the results were okay, then we'll come back to the farmer, sit down with you, and want to get as much information as possible as to how you stored the seed, how you did the planting, because sometimes the seed is okay, haikuwa na shida. But when it goes to the storage by the farmer anaistore mahali penye kuna moisture. Remember, seed is a living thing, right? So if it's a living thing and you store it in conditions that will enable it to start germinating, na iko kwa store. Ikishaanza kugerminate ikiwa kwa store, alafu inashtukia kumbe hizi conditions, they're not conducive kwangu kusurvive. Si itakufa. Si mnajua process of germination? The plumule and the radicle zimeasha kuwa active, zimeanza. Alafu zinarealize hakuna maji ya kutosha, hakuna mchanga, zinakufa. na mbegu yako inaiona tuko sawa kwa store, si ndio? Uende upande. Isipomea utablame nani? Na kuuliza wewe uniambie utablame nani?
Yourself.
Yes. Thank you.
We'll allow 3 questions. There was another hand there. Still, okay, 3, and then for the rest of time we'll take those and then we'll break. It's okay.
Thank you very much. Thank you, Violet, for that presentation. I just want to solicit your comment. You rightly said, really, you are service to the agriculture sector, to the farmer. And I'm saying you are inspecting and certifying a very narrow a very narrow spectrum of the food crops, or okay, they are few, they are limited. I don't know what you will say in terms of KIPI is going the extra mile to, whether by corporate social responsibility or something, to also bring these other crops on board for certification. We're certifying maize, we're certifying beans and wheat, and look at the indigenous vegetables. Not many people are coming up with new varieties because of, you rightly said, it's very expensive to come up with a new variety. So here we are as KIPI is narrowing on these limited ones. And sometimes I feel maybe that is why there are more roses and carnations, the flowers being certified, more than the food crops. And where are we headed as a country when the land is getting so small, the food choice which is being certified is so limited, and the nutritious foods, nobody's able to come up with a new variety, so you're just leaving them. What will you say as somebody from KIPI? Thank you.
Another question?
Thank you for the good presentation. I'm not an agriculturist or a plant breeder, but a business person. One of my trips outside the country, I came across a very nice pawpaw we are being served. So when I saw the tree at that very short period with so many pawpaws, I carried seeds. Reaching at the airport, they were picked by some people in the night as we alighted. I thought I was bringing new seed, maybe variety to come and increase my orchard. They warned me seriously at the airport. Maybe there was staff or the policemen, but the seeds were taken away. Just of interest.
I'm sorry for that. No, but I'll tell him why they took. Another question? Okay.
Thank you very much. My name is Alkamoy Boniface. We have sets of questions, but we are going to reduce to 2. And my colleague who is seated with me here will join with an independent question. Okay, thank you. So as a university, we have a lot of interest with farmers. More specifically, small-scale farmers in either dryland areas and also in the region where, which is the catchment of the university. And we wanted to move from a kind of a top-down approach and embrace a bottom-up kind of approach. This is not political, but we are looking at really what works best for our farmers. Personally, I come from a dryland area where people use land races, mostly in, I know Kenya seed has really penetrated for the maize seed crops, but for the other crops, which forms 99.9% of the seeds. And you find that communities there have a more of a social connections of sharing seeds. And on this other side, KIPI is very strict that seeds should not be sold. And if anybody is found selling seeds, and then they're liable of being prosecuted. So I just want your opinion on how do we make it better, especially for community-based seed systems, which as a university we are actually seriously focusing on that. And so that we are not against the law, but towards ensuring that we have a robust community-based seed systems for our community. And a recent study that was done by the School of Agriculture, which Professor Chodha is part of, actually identified that a very big percentage of farmers use their own saved seeds, and also getting seeds from the local market, which we also identified that there is very high incidences of counterfeit seeds. And let me not go there because already you have addressed that. So my interest is that really as an inspectorate, how are you going to ensure that we empower the community-based seed systems and really ensure that probably if there will be litigations in terms of punishment to the farmers or to the community, at least that is leveled. The other question is I'm just curious on what is the position of KIPI with regards to GMOs or GM products? Thank you. My friend?
Okay. My name is Alice Kipto from Baringot Technical College. I'm going to ask these questions as a farmer, not as a trainer. In some instances, you find that the sizes of seeds are too big, the ones that they sell to us, like now a farmer. Sometimes if you have, you might use 25 kilos of maize seeds for maybe 2 or maybe an acre. And sometimes these are not enough because of the sizes of the seeds that maybe you bought in a given year. Like for this year, I had to buy additional 10 kilos of seeds for the same size of farm that I cultivated last year. So is there a standard size of seeds that is required and should be distributed in the market? The next question is on identification of uncertified seeds. Previously, we were told as farmers, you just see if there is a KIPI card inside the package seeds. And at some point, they said you can SMS a serial number that is there for you to establish if the seeds are certified. Is this still functional for farmers, and are they aware of the systems of identifying the seeds? And finally, do you have any, I don't know how to put this, but there are a number of insurance companies that have come on board to insure our farms and farmers. So do you have any hand in whatever they do? Because at times insurances can come in just to take advantage of farmers. Do you have any hand in that? Thank you.
I answered those ones, eh? Now, where did they start? The first question that was asked by Anjichi was regarding diversification of the crop species that should be certified. I want to confirm to you that that is work in progress. As we are talking right now, there are so many crop species that are coming on board that are being certified. And actually it is in the law, the type of crops that should be certified by KIPI. So we have new crop varieties that are under certification. We even have the indigenous crops. We have managu, we have sorghum, we have millet, we have lucerne, we have chilies. We even have lately the forage crops like silage maize and silage sorghum, silage millet, which are coming on board. So I want to assure you that it's only a matter of time. If the breeders move with speed and discover or come up with processes of wanting to certify or to protect or patent any crop species, then that is something that will be of the past. We will be doing that because we are getting into that. Personally, I'm in charge of the variety testing department in the entire Kitale region. And as I do my daily work, I'm getting to interact with new crop species, some which I've never even seen in my entire life, but I interact with them on the ground, and then I go out to familiarize with them before I come and carry out work on them. So that one, we have good news for you on that one. Number 2, the pawpaw issue. KIPI has a mandate. Remember I said we certify all imports and exports of plant origin, and I talked of planting materials, fruits, vegetables, etc. It is required by the law. Before anything goes outside, it must be inspected, not anything. If I say anything, please just remember me, I'm a plant person. Siongelelei radio na television na nini. So the moment I say anything, think of me as plant materials. Yeah, so anything that goes outside the country that is of plant origin must be inspected at the points of exit. And during inspection, remember before you export, you must have a document from the importing country stating the conditions that your material must meet before it boards the flight. So while we do the inspection, we'll be doing inspection against that document. We call it a plant import permit. And if we feel that your material is actually complying to the plant import permit, we will reply via another document, which we call a phytosanitary certificate. That's the export certificate. And confirm that I have inspected and confirmed that this material is meeting conditions 1, 2, 3, 4, 5. If there's any condition there that that material is not meeting, it will not be allowed to board the plane. It will be rejected and destroyed or reshipped back to where it came from. Like if it's flowers, zitarudi kama zilitoka equator flowers, maji mazuri flowers, they'll just go back there. Or the owner decides anazidestroy at their own cost. Import now to Kenya, we also have conditions. Before you come in with those pawpaw seeds, you should have approached KIPI and asked them to give you conditions for import of pawpaw. Because remember, every crop species has got its own import conditions based on the issue of pests and diseases. We are protecting the country. We are not denying you from coming with those pawpaws that are coming to produce, and you get so many of them, and every family member will eat and have a feel. No. We are protecting this country, our agriculture, from invasion of foreign pests and diseases. What if that seed that you came with had these pests? You know we've had introduction of pests and diseases that we never had during our childhood days, right? So if this pawpaw has got a very dangerous pest or disease, ikuje uwe paipai zote Kenya, will you have done us any good with that seed that you are trying to sneak in? So it is very simple. Go to KIPI's office. Waulize wakupe import requirements. Kuna zingine zinakuwa permitted, zinaweza kuja. Kuna zile zinasemekana hapana, ziko na risk, lakini risk yake si kubwa sana. Inaweza kuja, but iwekwe under quarantine facility for observation. If it is confirmed to be free from those pests and diseases that we are dreading, you'll be allowed to go home with your seed. Alafu kuna zile zingine kabisa kabisa ni no way. They cannot come into the country. So kama hiyo iko kwa hiyo schedule ya zile ambazo haziruhusiwi kabisa kabisa kabisa, utaambiwa these ones are not allowed completely, we are sorry, you won't come with them. If they come in through the quarantine, you'll be given the procedures to follow. If they are allowed in, you'll just be given a plant import permit, so that where you're coming from, they give you a counter document that is confirming the material was inspected and it's free from the risk that will be stated in the plant import permit. And you'd have come with your seeds very well, and right now you'd even have distributed some fruits to us here. So next time you go out, please, even if you are there, call somebody in the country, tell them to go to KIPI's offices or apply so that you are given the right documentation. Unakuja tu umebeba, hata utaficha kwa bag, you just come carrying your seeds like this with your documents. And we'll be smiling and telling you, thank you very much bring them home. Let us improve our agriculture. The next question was about small-scale farmers and the bottom-up approach. We all really want all farmers to have access to seed na wapande kabisa so that we have food security in the country. But now again, selling seeds is not an uphill task. The requirements are very simple and very easy to meet. So if you want to sell seeds in that area that you said they are planting land races, imagine it is very simple. In fact, I'm sending you there as an ambassador. Go and open an agrovet there, but come to KIPI first for the right procedures. You comply, you are given permission, you are given a seed seller license, and then you start selling to them the certified seed, and you spread the gospel of the advantages, the pros and cons of planting certified seed. All these things are in the law. KIPI isn't doing things out of the blues. We strictly follow the law, because remember, again, if I do something and I'm not backed by the law, I'm liable to prosecution. So everything I do, I must first of all confirm, what does the law say? And then I follow the law. You've said there are counterfeit seeds. This one I want us to help each other. KIPI officers, we are very few. We are not all over. We are not in every single village and town and market. So we normally urge and humbly request our stakeholders and farmers and the public in general. If you come across somebody who's selling seed that you don't even need to confirm that it is counterfeit. You suspect. Me, I call it suspect seed. Tuvurutie tuwaya, drop an email, drop a complaint, wherever. It will be picked up very fast. And we will follow up. And you'll see our vehicles in that area. And we won't even mention you so long as you give us clear directions. This person ako mahali fulani na hivi na hivi. We come there on surveillance. We confirm. And you'll see prosecutions. People being taken to court for selling counterfeit seed. But if you see and then you don't inform us, na sisi hatujaona, utasema it is KIPI kweli. Hiyo sasa utahukumiwa dhambi ya omission. You saw, but you never said. So even if your village will be dying of that sin, hiyo jibu utajibu mbele ya Mwenyezi Mungu. Si KIPI, ni wewe utabeba hiyo msalaba. Because ungeambia KIPI, we would have taken action. There was another tricky one that I normally evade from answering. The position of KIPI on GMOs. This is a question that we normally leave it under the reserve of our CEO. Yes. And everybody in this room, they've got their own ideologies and ideas about GMO. Hata mimi nikijibu hii swali, I'll be answering as Violet Imbambi, Mrs. Kibet Kogo. Not for KIPI. Those will be my own personal opinion. Therefore, I beg not to answer that question. The sizes of seed. There was a question about the size of seed. Na msinifuate tukikula lunch mkiniuliza maswali. Me, when I'm eating. I don't answer that question on GMO.
Because you could be eating GMO.
Yeah, but GMO si mbaya. My personal opinion. Seed sizes, Si tumesema hapa kuna varieties aina mingi sana.
Yes.
Hata nyinyi wenyewe mkaniambia sijui 614, 6213 nini. Kila variety ukienda kununua iko na size yake. Kuna ile yenye iko mbegu kubwa, kuna ile yenye iko na mbegu ndogo. So there's no way you are going to buy the small seeded varieties and then you buy the large seeded varieties and expect them to cover the same. Wewe ukiamua unataka kununua ile variety na kuanga na mbegu kubwa, tengeneza pesa, nunua ile inatosha kupanda shamba yako. Kama ni ile ya tumbegu ndogo, pia nunua yenye inatosha kupanda shamba yako. Na huwa it's only that I don't remember it very clearly. There's a guideline clearly. If it is the small seeds, plant these kgs per acre. If it is the large ones or the small, iko kabisa. So please, before you buy, jua hii ni mbegu kubwa na inahitaji kilo ngapi per acre. An issue to do with certified, identification of certified seed. Yes, the SMS is still in operational. I've tried to remember it in my head. Nimesahau hiyo namba kidogo. But for you to be able to know seed is certified, although Kenyans wako rogue, mi hata wamenishinda. They come up with seed packages yenye ukienda hivi unaona inafanana na ile ya Kenya seed kabisa. Mpaka hata wameweka lot number. Siku nitaacha hii maneno, Kenya will be a very good country. You go, wewe mwenyewe hata unaangalia hivi you're like, na mbona inafanana Kenya seed kabisa. So when you see the lot number and then you go to the system, ndio hakuna hiyo kwa system, but the thing is ni Kenya seed packages ya Kenya, mpaka kala ni ile ya 2 kgs mpaka wamejua. Sasa sijui ni wenye in-house people who wanabeba their packages and then they go, I don't know. Have I said anything? I'm not accusing anybody, but I'm just saying I don't know. Yes. So what you do, our lines are very open. Even on our website, kuna portal hapo hivyo ya complaints. Drop a complaint there. And when you're dropping a complaint, be very specific. Usiseme tu, there are people who are doing, No. Sasa utasaidiwa aje. Ukisema tu watu wanasema, no, give us evidence that there's this issue. We want you to address it. It is in this location, blah, blah, blah. Even if you have your contact number and you feel like leaving so that we can call you in case we don't really get the details we need, we can call you, you guide us. You'll not accompany us. You'll just give us direction and then we will go and do it. So if you're suspecting that hii mbegu si certified, lakini imepakejiwa ni kama iko, although you're supposed to check the lot number and then try to verify the logos of the company if you know them well. But if you're in doubt, please run to KIPI. We will come in and confirm that for you. The last question was on the insurance companies. Sisi wote tunajua insurance companies ni watu wa kutengeneza faida. Hata ya madawa tunajua medical insurance, you insure yourself, but the day you become sick and you want them to come and pay the bill, they are not there. Those who have cars, you have car insurance, they've said, everything the deal inakuanga so good. Ngoje upate accident ama kitu ifanyike, unataka sasa wakuje. Unazungusha mpaka sometimes unaamua to hell with them. The hassle you go through trying to reach them to help you is too much compared to if you just sorted out your issue. So, hiyo pia nayo ya insurance companies, hiyo when they come to the ground, ni watu wamekuja kufanya biashara. So when the deal is too good, think twice. But just know there's no insurance company that gets into the market to make losses. So before you sign their documents, just do your background check. What is the integrity of this insurance company? If it has worked somewhere else, na ikawafanyia, are we assured, are we guaranteed that if we enter into this negotiation and deal with them, they are going to give us value for the deal? I will leave it at that. That was the last question. Thank you.
I think we can do a better clap for better than that. Thank you all for your patience. I can see there is a lot of interest that has been generated, but she said spare her to have her lunch. Then probably you can pick up from there. So we appreciate your presentation, and it's time for us to break for lunch. I'm being told to introduce myself. I missed out the session. My name is Wambui Ng'ang'a. I'm the Corporate Affairs and Marketing Manager, University of Eldoret. Yes, we were at volunteer to pray for lunch. Sorry, before you pray, our lunch is served at the guest house upstairs. You will receive coupons as you leave. So go ahead.
Thank you, Father. We say thank you for this afternoon. We say thank you for the sessions that we've had from morning. We glorify your name even as we take the lunch this afternoon in Jesus' name.
Amen. So enjoy your lunch. Mr. Chege, you're good to go. Thank you.
This afternoon we are going to have two presentations, and we are planning to do them one after the other, so that we have the discussion towards the end. So we are going to take about 25 minutes on each at most, so that we have 10 minutes as we approach 4 to have a short discussion. Then we can wind up the day. So the first presentation is on trademarks, and I think this is not a very strange concept. Trademarks have been part of our lives, and they are part of our lives every day. And in order to be able to use the time available efficiently, I won't follow the presentations as they are arranged on the slide. So I'll try to jump back and forth just to highlight the key important things that you should know about trademark. Trademarks are administered, or they are governed by the Industrial Property Act, Cap 506 of the laws of Kenya. And Kenya Industrial Property Institute is the institution mandated with the registration of trademarks. So if you have a trademark that you are using in a business and you would want to protect that trademark by registration, or you have a mark that you intend to use in the course of business, either in connection with provision of services or provision of goods, then you can apply for registration of that trademark as provided for under the Industrial Property Act to the Registrar of Trademark. You can request the registration by submitting your request to the Registrar of Trademarks. When I say the Registrar of the Trademarks, as you know, the CEO of KIPI bears two hats. He is the Managing Director of KIPI, and he is also the Registrar of Trademarks. So when you find a certificate signed by the Registrar of Trademarks, it's still the same person as the managing director. So you'll find patents, the person signing there, the title is the managing director. Industrial design certificates are signed by the managing director. But you'll find communications relating to trademarks being signed by the registrar, or on behalf of or for the Registrar of Trademarks. I don't know, is the connection still on? Should I hold or I just continue? is the managing director of KIPI, and he's also the registrar of trademarks. So he has two titles. So if you want registration of your trademark, then as provided for under the Trademarks Act, you make a request to the registrar. That being said, so what is a trademark? In very simple terms, a trademark is simply a sign or a symbol that is used to distinguish the products of one enterprise from those of others in the course of trade. So a trademark is simply a mark, where a mark could be a device, a GUI, a signature, a word. It could even be the shape, like the shape of this bottle. Any sign that can be used to distinguish the goods or services of one trader from those of others in the course of business. That is what we call a trademark. Registration is not mandatory for a sign to be recognized as a trademark. The very fact of a sign being associated with particular goods in the course of trade, such that that sign serves as the identification of that product. That is when it acquires the insignia of a trademark. But we do have registered trademarks and unregistered trademarks. There are people using their marks out there, and they have become recognized and acknowledged as the owners of those marks, but they have not applied for registration. Okay? Ukienda hapa nje utakuta kuna mtu anafanya kazi ya hoteli ameandika Mama so and so hotel. That is a trademark. She's using that as the identification of her restaurant or hotel services. And people know in the surrounding. Ukituma mtoto umwambie enda kwa let's say Kimani's butchery. He'll go straight to that very specific one because it's known by that name. So, by virtue of use, that particular name has been associated with those particular services. And therefore, it has acquired the insignia of a trademark. So when we talk about trademarks, it's nothing strange. They're things we have used and we encounter almost every day. And they're simply signs or symbols that we use to distinguish the goods or services of one entrepreneur from those of others in the course of trade. In the course of trade. Can I scroll down? Is it possible to scroll down? Yeah.
Scroll down.
Go presentation.
It could be like the real presentation in Mafanya.
Ndio hiyo.
Like tunadai to stream sasa through YouTube.
Okay. So the signs can be of different kinds. Some of them, as defined under Section 12 of the Trademarks Act, it can be the name of the enterprise or the entrepreneur. It can be an invented word or words. Okay. It's okay. Let me just do it. So it can be an invented word or words. So these are words that are coined that have no relationship with the product. It could also be ordinary common words that are found in our languages, but which do not refer to the quality or quantity of the product. They don't describe any aspect of the product. So those are recognized as trademarks. Any other sign, apart from those I've mentioned, can be registered upon proof of distinctiveness. Because for a mark to be registered, it must be inherently capable of, or in actual case, it is adapted already to distinguish the goods or the services of the different enterprises in the course of trade. And they come, as I said, in different forms, as I defined there before. So we have those which are figurative in nature. I know you've seen this before, isn't it? The first one here, at the corner here. Whose trademark is that? Which institution is this? The first one? Top right corner. Eh? No. You have not seen it anywhere? Are you aware of the logo of the University of Eldoret? It's the first one there. That is this device here. Okay? Without the descriptive words there. So, that logo is part of the trademark for University of Eldoret. I think it's registered. It's on the register of trademarks as a registered trademark. But however, even in the due course of trade, it has acquired that association with a particular entity. Okay? Because they've been using this as the symbol for their recognition when they are offering their education services. When they are offering the various other services that they provide at the university in relation to education, research, and the likes. So whenever you see that logo, immediately you know, even before you see the name of the company, that you are able to acknowledge the relationship between that sign and the university. Then there is the next one. Which institution is that? The one in the middle here, after. Huh? VTTI. Yes, you're right. The next one after that? Hmm? The Eldoret National Polytechnic. So this is one aspect of it. It can be a symbol, a sign. And through that link of being associated with a particular entity, there is that relationship. So by virtue of use, by virtue of registration, these marks have been associated with particular entities and with the provision of particular services. The other type of trademarks, let's see, where are they? They can be numbers. If you see 0722, what do you think of? Safaricom. So there's no doubt in the consumer's mind that there is that connection in terms of services, the sign, and the owner. It's usually a triangular relationship. If you see 504, Peugeot, that vehicle from France. So it can as well be numbers, and it can as well be a letter. If you see that first symbol there, straight away, it's McDonald that comes into a person's mind. If you see HP, Hewlett Packard. If you see that those two R's combined, which company is that? Exactly. It's Rolls-Royce, the motor vehicle company. So even the letters can be used as signs for distinguishing the goods and services of the various entrepreneurs in the market. And you can have combinations of these elements. Okay? So the first one there is Safaricom. So how many elements are there? Because it's a combination of several elements. There is the device element, which is the circle, the red part of it. There is the word Safaricom, and you can have a slogan, Kuna Twaweza. So the whole of that forms one mark, but it has several elements in it. You can have a combination of numbers and letters. You can have combination of letters and devices, just like in the case of Safaricom. You have for the Equity Bank, you can see the various elements combined in a unique way. And they are things that you automatically, upon seeing, you are able to connect that with a particular entity. Signature, I talked about signature. See this one? Other Guinness. The owner of that brand at the bottom there. It's recognized as a trademark. And you normally find in every bottle of Guinness, the genuine one. That trademark is there. By the way, trademarks are used to also distinguish the genuine products and the non-genuine products. So these are some of the examples of trademarks from other universities as well. And a trademark can also be a slogan. You can actually register a slogan as your trademark. Frame of knowledge and innovation. Toweza. The better option. Foundation of knowledge. Ufundi kwa maendeleo. Ufundi kwa maendeleo. The Eldoret National Polytechnic. Sapientia difficile E. Knowledge is wealth. That is Chuka University. That is Chuka University. Normally, the slogans are usually catchy words, and in most cases, they want to describe a particular aspect, or value that they want to promote with the services or the products that the organizations are offering. So basically, that's an overview of what may go and may be registered as a trademark for the purposes of differentiating different products and services in the market. So what are the key considerations that you should take in place when you are coming up with a trademark? One thing, you need and register it as a domain name, or there is nobody else using the same word or the same name as a domain name, because the prior user of the word will have that ownership. As I said, there is that connection of the trademark being applied to goods, and there is the issue of being recognized as the owner by virtue of use of the trademark in the course of trade. As I mentioned, the registrar is prohibited from registering similar or closely resembling marks. It's also likely that your trademark can be refused if it can deceive or confuse the consumer. If it's contrary to law, order, or morality, if it's a scandalous design, and if you are taking some well-known mark out there and you bring to the office for registration, we shall not allow registration unless there is consent from the owner of the trademark. Then the national flags, national emblems, those ones are not registrable as trademarks. Why should we register a trademark? As I said, you can own a trademark by use. But the purpose of registering a trademark is for you to benefit from the reliefs and the benefits provided under the Trademarks Act. If somebody infringes your trademark, you can take him to court and using the provisions that are available in the Trademarks Act. And you can get relief for damages, and also you can be issued with the injunctions and whatever to stop the infringement continuing. So that is the most important and basic reason why trademarks should be registered. And not only that, there is also the issue of the ownership existing on a record, and that becomes easy if there is a dispute over the ownership of the mark, just like we have land and other properties. The register for trademarks keeps record of those rights. Even after registration, when the marks are transferred from one entity to another, those are recorded against the entries of that trademark on the register. So you can even track how the trademark has been moving from one person to the next. Trademarks have value. In 2021, Amazon was worth $683,852 million. These are millions in dollars. They are dollars actually. And it had achieved an increase of 64% from the previous year. Apple was worth $611,997 million, with an increase of 74% between 2020 and 2021. So, brand names are worth big values. Do you know the mark Nice and Lovely? Nice and Lovely. That blood was started by somebody in his backyard here in Nairobi. He went on to become a national brand, then to a regional brand, and then it was sold to an international company. And it was sold for 1.5 billion Kenyan shillings. After how many years of developing it?
From 1995 to 2013.
95 to 2013.
And he started with 3,000 shillings, hawking the lotion.
And he started making the lotion in his backyard and then hawking. It acquired a reputation And after those few years, he was able to sell it for 1.5 billion Kenyan shillings. That is the power, and that is how wealthy you can become by building a reputable blood. And you only need to start humbly. And you don't need to start with a complicated invention. You just need to have a product that is wanted in the market, and you market it properly, build that confidence with the customer. Build a following, a market for your product. You can see Elliot is back on the market. Elliot, yes. The blade. And there was a time it had literally gone kabisa. It was not in the market, but it's coming back. So even after the initial enterprise that was producing that blade went, I think it went to liquidation. They could no longer support themselves in the market. The brand remained. The brand has now again been, I think, sold to somebody. So somebody is using it to produce. I don't think it's the original Elliot producers who are using it. It was traded. So you can actually build value by building a brand. So how do you acquire the rights to a trademark through registration? The first thing that you need to do, as I said, is you need to carry out the search. You need to check whether there is another mark existing or being used by somebody else. And the best way to do that is to search in the trademark register. That is the beginning point. But you can also search in other databases. You can just Google the word or whatever sign that you want to check, and then ensure that whatever word you're adopting is not being used by somebody else in the market, or it's not closely resembling to another one in the market. Then, after you've done the search, then you can lodge a request for the registration of your trademark. So that would be if there's no other conflicting mark in the market. Then, once you lodge the application for registration, it will go through search, advertisement, and we advertise so that those people who have any interest or who would be aggrieved by the registration of that trademark can come up and raise an opposition. And we allow for 30 days after publication in the Kenya Industrial Property Journal. So if there is no opposition, we proceed to put the mark on the register. If there is an opposition, then you have to go through a process of hearing, and the registrar then will determine the matter and give further direction as to the registration or denial of the registration. There are, as any other property, there are mutations that happen after that. Things are sold, things are leased, and all that. So all those are also recorded on the register of trademarks. Again, it's the registration of that trademark. So there are those post-registration activities that happen. I wish to bring this to a close at this point. You will get the this slide, so you'll be able to follow the other details. But I think I've captured the key, the gist of the trademarks topic, as it were. So I will invite my colleague to take you through the design. That should take
20 minutes,
maybe about 10-20 minutes.
10 minutes?
If you can do it in 10 minutes, then we can open then for discussion. Yeah. Because there is a bit of relationship between these two. Just come here.
So, welcome again for the next session. And just like we've been discussing about the importance of registration of intellectual property rights, industrial design is one of those IP tools that is also used to secure the valuable assets of a company. And so what is important in this case is just basically to, first of all, define what an industrial design is. What does an industrial design protection entail? It protects the aesthetic aspects of a product, okay? It protects the ornamentation of a particular product that make it attractive in the marketplace. It doesn't protect the technical features because that falls under patents. This is industrial design. It has everything to do with just the beauty. And the reason I even carried so many bottles is because these are industrial designs which are different. And if you go to the shop nowadays, you will find that there are so many shapes. You will be spoiled for choice. And the reason you will be spoiled is because individuals are different. Various designs that have different aesthetic values attract different market segments. Okay? And one of the examples that I wanted to give, already my colleague has given, is the one of the nice and lovely. If you have time, you can Google Paul Kinuthia or the Interconsumer Products Limited, which was selling body lotions, a wide range of them, a brand of them, nice and lovely, which we have just been told already that they sold it for 1.5 billion. And in fact, that is the most important point here. The fact is the designs that they made to package those particular products made it a very strong selling point for the particular consumers in the marketplace. And indeed, we were being told this guy spent 3,000 shillings. He was actually hawking from one shop to the other, one saloon to the other. That was 1995. So by the year 2000, at that time he was selling without registration of a trademark and the packaging material. He realized that there was going to be serious competition because I think there was a demand. So he immediately rushed to KIPI and filed for the registration of the trademark and the design of the various bottles. You will see them. I've actually downloaded some of the bottles that you see that are very easy to open, and when you handle them, you feel comfortable with them. The design makes it, attractive for that purpose. So what happened was in 2001, he realized he was going to lose the market to other competitors. So in 2002, he registered the trademark for the various brands and also the design of the packaging. And from that time, he employed professionals to work on the packaging of those containers. And by the year 2013, he was approached by a foreign firm, a L'Oreal company, which they negotiated for 2 years. That was a very difficult task because this is something that you require to put in a lot of effort in negotiation. Because you have to look at the milestones. What are you likely to lose for short-term benefits? So there were experts that were employed to negotiate together. And by the year 2013, they sealed a deal at the tune of 1.5 billion. And you will Google that, and you can bear witness with me. The guy is called Paul Kinuthia, and he has since divested into sanitary care, diapers, manufacture diapers, because now he has left the lotions to the French company, which is called L'Oreal, which is already marketing that particular nice and lovely, because they were fighting over the trademark, which was dark and lovely, and this one was nice and lovely. And he had gone to Uganda to fight the case where Ugandans were trying to say soft and lovely. So he didn't win the case because he had not registered there. So he came back and sat. And when he realized his product was selling, he quickly, registered the names, the trademarks, and the designs, and later on negotiated and got that particular deal. As we speak, the guy has employed 500 permanent employees and 6,000 salesmen and women on the ground. And that is just because of the IP, nothing else. It was just about the packaging. You can see the power of the IP. And that is why we are saying IP can be a very strategic business asset which you can leverage to make money. Such a person has made money. He can continue to make money by even designing more products and selling them. You know, it can be a business where you design, manufacture, and sell. You no longer have an interest. Like now, you no longer deals with lotions. It's now going to diapers, which is another very serious market. There are so many things that are needed in that particular sector. So the reason why I brought up that is because I'm just trying to say that this particular IP, when you know what you want and you strategically plan, you can be able to reap benefits. And that's why the concept of the reason why you get protection is when you disclose the rationale of registration of industrial designs or patents, for example. You see, you reveal the invention in form of patent. If it's a design, you reveal the design innovation, and then you get the exclusive rights. And this guy got, and he was alone. So he was able to negotiate as Paul Knudia. So the fact of the matter is that you must disclose. And when you disclose, you get registration. And that is exactly what happened. So it helps to strike a balance between the private interest of that individual, who is the inventor or the innovator, and the public interest. The public benefited by consuming those products, and therefore creating a huge market for purposes of selling those particular products. And as you can see, it attracted foreign investors, which are now have taken over. If you go to Mombasa Road, L'Oreal is now the name that is running that particular product, I mean, selling in the marketplace all over the world. Like I said before, it is because of the attractive nature and appealing, because all of us consume different things for different reasons. If we went to the supermarket today, somebody will grab a different mineral water from the one that I will pick for aesthetic purposes. I mean, because it do not depend on the interest of the individuals. So that is really what happens. And so the reason for registration is really to prevent others from using or producing and selling the particular innovation that you have registered. And again, like Paul said, it's about you having the certificate that if somebody infringes on your product, you will be able to go to court, and the evidence will be the certificate. And you will see the certificate later on down there, which I've attached. One of the certificates that is issued as an evidence that you have registered the design. It is, like I said before, is a useful tool for identifying opportunities for partnerships. You can actually partner. And if you think that your potential competitor is likely to run you out of town, you negotiate to strike a deal. He can be an ally rather than a competitor. You can simply do a joint venture, for example. And at the same time, it is also a strategy to avoid infringement. You are telling the potential competitors that, hey, by the way, this is a registered design. That is why you find in this particular bottle of design, Dasani, it says registered. For purpose of registration of trademarks, it is Dasani and registered. R there means you are warning the potential infringers that this is protected. There will be legal action if they happen to infringe on your product. So you can actually license, and licensing means it's like you are hiring your shamba out. If you want to hire, it's like you are renting your land. You still have the control, but you get some benefit out of it. But like this one of L'Oreal, they assigned. Assignment means selling. You have no interest whatsoever. It's like you sell land once and for all, you gave out the title. But in this case of license, you still have control. You can simply say, I'm listing this thing for the next 10 years within Kenya or within Uganda, because these rights are territorial. If you register in Uganda, you license one person in Uganda or two. Usually when you license one person, that's exclusive license. Non-exclusive license is where you have more than one dealer in your product. So you have control, because you can even withdraw if somebody abuses the market, the market structure for the future. Once again, I think the issue of the newness, the design must be new. As in, when you go to the marketplace, it has not been disclosed before in the public. And it must be original. Original means you designed on your own. And it has to have what we call individual character. So that when they stand out like this, you can simply, by the look of it, you can be able to differentiate without being told that these indeed are different from this one. They are all different individual designs. So it's called individual character. And that individual character is normally identified by the person who deals with containers. And this person is called informed user. In the eyes of an informed user, the one who deals with them on a daily basis can be able to say, hey, this one is completely different from the other. So that in the what they are saying in the overall impression of the design from the informed user's point of view is completely new. You can simply say it was never available in the public. Procedures of registration, basically, usually there is a form that is filled, which is IP form number 3, number 43, which is, again, the status, like my colleague said, is request for search. You may want to register a design that already is in the register. So you have to confirm, first of all, just in case there is a mark that exists already, so that you don't waste your resources filing and it will be rejected eventually. So once you get a positive report that there is no conflicting design in the register, you are issued with the application form 27, where you now load your application, putting in the details, filing the specification, which means you have to attach the photographs, the technical drawings, and giving the various views, as in when you are describing a technical drawing for a design, you have to give us the bottom view, the side view, the top, bottom, and side view. Those are called various views that you are relying on as new. Because basically what happens is that when you're giving us those views, you are trying to identify what is unique about it. In this particular case, the unique design in this particular case is the patterns that are running parallel along the bottle. So if you beautify that particular bottle, you should be able to say, this design, I rely on the novelty or the newness on the patterns that you have planted on that particular thing. I think the ownership issues, what I was trying to say initially, the fact that the IP rights are territorial, if you hold a design registration in a particular country, it does not mean you have extended protection unless you go and protect in that particular country. And there are procedures of filing. If you file a design in Kenya and you have not filed in Uganda, you have no right to block that particular person from copying, because you have to seek for protection in that particular country. Remember, this is supposed to be something that you continue to renew and maintain in the patent or the design register. So if you are not paying for anything, you cannot go and claim in Uganda that you are copying my design unless you register. So it's like we were saying, your balance is the public interest and that of the inventor or the creator. So holding up a design protection in country A cannot give you the rights to prevent others from making and using in that country, the other country. Again, what I was saying, the rights of the owner to license, that was mentioned, negotiation, mergers. I think it was mentioned, was it yesterday, with the negotiation regarding the sale of Kimbo, the brand, and even their packaging. It was 100 million at that time when it was sold to, was it Bitco, something like that. So it can be used as a negotiating tool. That certificate is very important. As we speak right now, most of our companies have not come of age, and most of them, if we compare to the Western world where they use their trademarks or design registrations or patents to secure loans in the bank. You simply deposit your certificate and say, I want 1 billion, like Coca-Cola can do. And there is no doubt they will get a loan. But I think where we are yet to appreciate, and that is why this awareness creation is coming down to where we are. And I think from that nice and lovely, you are learning a lesson that you can make money from anywhere. We are no longer talking about Coca-Cola, we can now talk about our own homegrown solutions. So you can do something, invest a bit, you know, harness the product and then do proper marketing, and then you will recoup the expenses. And that's why there are limitations in terms of duration of protection. You are expected to have recouped your expenses for the design after 15 years. As for the patent you were told yesterday, this 20 years, again, all of them are subject to renewal. For the designs, you renew after every 5 years, and it is very cheap. And the reason why I think the design protection is 15 years, because the type of evolution that goes on, the technology that goes on in the design field or sector, is that the turnover of innovation is so high. So if you block people for the next, let's say, 20 years for purpose of patent, you are doing nothing. You are just trying to block people from being creative. Because look at this, they are very close, but then there was small amendments. You simply use a mold that can press and do some patterns on the bottle. And the bottle existed anyway. So basically the issue is you can do something about an existing design to make it more unique, and you get protection that way, and then you proceed. Usually, the obligation on the part of the owner of the design is usually to police his own design in the marketplace. Usually, the person who owns a design, a registered design, must be able to look for potential infringers. Like I said before, you should be looking out for potential infringers just in case they do infringe. You can take legal actions, seek the services of the courts to seize those particular products, or maybe institute injunctions depending on the situation on the ground. So what we were saying about the industrial designs, if somebody discloses a design 6 months before filing, you will not lose what we call novelty. But after 6 months, it will be treated as though it was in public domain, and therefore it wasn't new at all. Like the other people, or like all the other IPs, there are limitations and exceptions. You cannot prevent people from using it for research purpose. This has been said since yesterday. I had the copyright people, the KIPI people, we also do the same. This is because all these IP. You cannot prevent people from using it for purpose of research because they are not making money. The bottom line was, if you made money, then you're already infringing. And if you are caught, you'll perhaps compensate the person the amount of losses that one has made. Private use, same thing. Use for teaching purposes, you cannot prevent. Prior user, there would be this person who already used this particular innovation and may not have registered. But somehow you took advantage. Is it advantage? You thought you are aware of KIPI, and therefore you quickly dash. For this person, he didn't know that KIPI exists, but he has been using. All of a sudden realize that you are already registered. You cannot prevent that person because they can prove backwards that, look, I was using this design 2-3 years ago, and you are filing today, and you. So these are some of the things we are saying we have limits. Again, designs incorporating protected official symbols or emblems. Again, like the military insignia, the national anthem, emblems, all those things cannot be allowed. Anything that is contrary to public order and morality. There are many funny designs that have been designed by other foreigners and they want to come into the country. I remember Chinese designs on very funny things, and we decided to, under the law, this cannot be allowed. If you check the kind of designs that these people from, I think I saw some from Japan and China. They may not be, just like my colleague said, they are abusive or they offensive in a way. So you can imagine. So when they come here, our law is very clear. Some of those things to do with morality cannot be, accepted at all. The other thing is about renewal. I just mentioned about the renewal fees, conducting seizures and from potential infringers. Term of patent, I've talked about it, 15 years, subject to renewal every 5 years. But if you fail to pay the fee in the course of the life of this particular industrial design registration, it falls into public domain. And somebody can raise an issue and take up. And we have seen many people coming up. When somebody realizes, because normally competitors come and search the status, validity, what you call validity search. Is this still valid? Is the owner still maintaining? If we discover that this is not being renewed, you have no business, because I think the contract was, we give you exclusive rights, you pay us. You pay the government to secure you with that particular protection. So if you are not paying, then you have no contract. And when that contract disappears, and it normally is normally published. If it is not renewed, the journal which we have will automatically pick it up and publish it as unrenewed. And therefore, it goes into public domain. And if somebody has an interest, will come and take it up, and we can be given. These are some of the examples of the various designs that we have registered in KIPI. A Coca-Cola bottle, which is like I said, is also registered as a 3-dimensional trademark. But in this case, in the register of designs, it's just the overall shape. In this case, we are not concerned about the cork, but the shape of the bottle. But when it comes to trademarks, they can register the whole thing, so that it's a package. Nobody, and therefore, in fact, the beauty about registering in a 3-dimensional trademark is to ensure that they renew forever, because designs expire after 15 years. So even if you wanted to emulate or copy this one, you will be told our trademark 3-dimensional design is still valid, and it will be valid forever. In fact, I am aware you must be knowing that Coca-Cola has existed for about 100 years, and it still continues to monopolize that particular market with this portal, because it helps them to penetrate the market, because you identify very easily. The same thing to that other thing called the